Just for clarity, neighbor-to-neighbor harassment will be the next panel here, or a presentation in this room. Outside, where you see there's chairs and the stage, will be the housing huddle, where there will be various topics sort of like rapid firing at you. All right, so that, and then at 11, we'll return here for the gentrification panel.
He has a remote though? Do you have a remote? Yeah.
So good morning again. This session, the neighbor-to-neighbor harassment under the Pennsylvania Human Relations Act, will explain the delicate process of investigating a neighbor-to-neighbor discrimination complaint. The speaker, Ms. Director Lawwood, will explain how the PHRC investigates and adjudicates these cases. Lawwood is the director of the Pittsburgh Regional Office of the Pennsylvania Human Relations Commission, where he directs the enforcement of the Pennsylvania Human Relations Act, overseeing 26 counties in Western PA. Before coming to the commission, Wood was a general manager in the property management division of builder developer Crossgates Incorporated. Subsequent to his 4 years at Crossgates, Wood also worked as the senior housing counselor at the Urban League of Greater Pittsburgh's County Housing Counseling Unit, assigned to comprehensive housing counseling issues, and conducted default delinquent mortgage counseling for 8 years. On January 19, 1989, Wood began with the Pennsylvania Human Relations Commission as an investigator, investigating housing-related discrimination complaints. He was appointed investigative supervisor, expanding to all other areas within the commission's jurisdiction, and has served as regional director since July 2016. Please welcome Director Wood.
No.
There you go.
Okay, there we go. There we go. Talk right into it, and we're good to go. Good morning, everybody.
Good morning.
Okay, and welcome to PHRC's Fair Housing Conference. I've been with the commission for the past 34 years. I spent about 23, as you heard, as an investigator, investigating neighbor-to-neighbor complaints. I would say of all the complaints that I've investigated and looked at, neighbor to neighbor, if there's any investigators in the room, can be some of the most challenging types of complaints that you have. Many times people think that it's just adults acting badly, and that's not the case. There are many other issues, some of the same societal issues that we deal with in the commission that takes place. And many of those disputes are because of individuals' protected classes and the biases and prejudice that people have. And they're right next to each other, which magnifies them even more. One of the great people, and this will kind of segue us into the discussion, a great Pittsburgher, is Fred Rogers. And if any of you know who Fred Rogers is, Fred Rogers, Mr. Rogers' Neighborhood, talked about neighbors. And in honor of Mr. Fred Rogers and the topic, I will start off with, it's a beautiful day in the neighborhood, a beautiful day for a neighbor. Would you be mine? Could you be mine? It's a neighborly day in this beautiful wood, a neighborly day for a beauty. Would you be mine? would you be mine? I have always wanted to have a neighbor just like you. I've always wanted to have a voice. I've always wanted to live in a neighborhood with you. So let's make the most of this beautiful day. Since we're together, we might as well say, would you be mine? Could you be mine? Won't you be my neighbor? Won't you please? Won't you please? Please, won't you be my neighbor? I promise, it's not going to be an encore at all. So we can kind of get started. I tend to walk around and talk a lot, so I'm more comfortable that way. So we can advance this slide to the next one. There we go. Fair housing in Pennsylvania, it's your right. You have an absolute right and a human right to fair housing. Housing dictates a lot of things. It dictates where you go to school many times, where your children go to school, where you're employed, your quality of life, your equity, with the generational wealth that's passed down through housing in terms of actual property owners. And it's important that we understand that. It's important that we look at the rights individuals have as just not somebody who's just stuck next door to you, just as somebody who's different from you, but an absolute right that all, not even citizens, but all Pennsylvanians have, all people in this country have, all people in this world have. I've been a lot of places in this world, and the one thing I can say that's a commonality and it's intersectional is the fact that people want a decent place to live for them and their families. So it's important that we recognize the fact that people have rights. The Human Relations Act mandates those rights and privileges that all of us in the Commonwealth of Pennsylvania have. Okay, next slide. The training goals for this session: to provide an overview of the Act and its corresponding sections, to discuss neighbor-to-neighbor harassment under the FHA, Fair Housing Act. We get into acronyms in our own, what I call PHRC speak and Fed speak. So if I start to kind of digress into that and I'm being confusing, just let me know and I'll speak English so everybody understands what I'm talking about and not PHRC speak. Investigation. Oh, great, thank you. Okay, thank you very much. Investigation of neighbor harassment, which is what it is. It's more than a dispute. It's more than, I don't like your music. It's more than, boy, what you're cooking smells funny. It's more than, your dog just urinated on my lawn. It's more than, your kid's ball is in my yard. A lot of times, it's a matter of actual harassment because of an individual's protected class more than anything else. And we'll look at evaluating a case that involves the concept of neighbor-to-neighbor harassment. Evaluating the defenses, okay, that you hear, and particularly investigators, that you hear all the time. I didn't do that, and this is why. But the defenses are important. And hopefully be able to answer your questions. When I was a younger investigator and doing presentations, I was arrogant enough to say, ask me a question I can't answer. Well, with time and experience, I've learned not to do that because there's more questions than there are answers. Okay. There are 3 approaches to harassment claims. 1, hostile housing environment under subsection 3604B of the Fair Housing Act, also known as Title 8 of the Federal Fair Housing Act. 2, discriminatory, and section 5H3, it deals with terms and conditions under the Pennsylvania Human Relations Act. Number 2, discriminatory statements, subsection 3604C of the Fair Housing Act, and section 5H5 of the Pennsylvania Human Relations Act, and interference, also known as coercion and harassment. We also look at that under our act, the Pennsylvania Human Relations Act, as retaliation, under subsection 3617 of the Fair Housing Act. Hostile housing environment. If any of us have had issues with neighbors who weren't particularly cognizant of our right to quiet enjoyment, which we have, which is a lot of times a landlord and tenant construct right to quiet enjoyment. And people will say, well, you don't enforce quiet enjoyment under the PHRA. Well, we don't exactly. We enforce terms and conditions. We enforce harassment. We enforce those types of things that adversely impacts on individuals as a result of their protected class. So we do that. Under the Fair Housing Act, it is illegal to discriminate against any person in the terms, conditions, privileges of sale or rental of a dwelling, or in the provision of services or facilities in connection therewith because of race, color, religion, sex, familial status, the presence of children under 18 years of age, or national origin, under 42 USC subsection 3604B. And the corollary under the Pennsylvania Human Relations Act will be it is illegal for any person to discriminate against any person in Section H in the terms and conditions of selling or leasing any housing, accommodation, or commercial property, or in furnishing facilities, services, or privileges. Okay, let me read that again. Furnishing facilities, services, or privileges in connection with the ownership, occupancy, or use of any housing, accommodation, or commercial property. Okay, under the PHRA, and that's why I kind of hedged on this one, the definition of person or persons under Section 4A of the Act states that the term person includes one or more individuals, partnerships, associations, organizations, corporations, legal representatives, trustees in bankruptcy, or receivers. It also includes, but is not limited to, any owner, lessor, assignor, builder, manager, broker, salesman, agent employer, independent contractor, lending institution, and the Commonwealth of Pennsylvania, and all political subdivisions, authorities, boards, and commissions thereof. So you can see it's a very broad definition that covers a lot of territory, which for us is good. When a complainant comes in and we investigate a complaint, we have to have the latitude to be able to interpret the act liberally. That's what we're charged to do. This gives us that ability to be able to find the area of jurisdiction that we need to be able to charge a complaint. Hostile housing claim elements, and this is important, that the conduct was unwelcome. Conduct was because of a protected class. Conduct was sufficiently severe or pervasive, and it could be severe and pervasive, to alter the conditions of housing, and some basis to find a particular defendant liable for the conduct. And we'll talk a little bit more about this later in terms of conduct. Discriminatory statements, and this is important because one of the things when we were partnered with HUD is that if we had neighbor-to-neighbor complaints, and this was back in the old days, and we had neighbor-to-neighbor complaints, if there were statements made, then we would have to contact them because we didn't have jurisdiction over First Amendment issues, okay? And many times people will say, oh, what I said was covered under First Amendment. Oh, my behavior was First Amendment. That's an important thing. And then HUD would take them because they had jurisdiction under Title VIII to deal with First Amendment. But you'll see, we'll get to that so that we can answer those types of questions or answers that we get from our respondents. Whenever we charge a complaint and that complaint is served on the parties, the respondent party, defendant, has 30 days to provide a written, verified answer with specificity to the charge of discrimination. And inevitably, what you see in a lot of those answers is, oh, that was First Amendment behavior. You know, there's no jurisdiction under the act. And so we're going to dispel that, pretty quickly a little later on. Okay, again, the PHRC corollary under Section 5H5, to print, publish, or circulate any statement or advertisement relating to the sale, lease, or acquisition of any housing accommodation or commercial property which indicates any preference, limitation, specification, or discrimination based upon use of a guide or support animal because of the blindness, deafness, or physical disability of the user, or because the user is a handler or trainer of a support or guide animal. Okay? Discriminatory statements and the claim elements for discriminatory statements. To make, print, or publish, or cause to be made, printed, or published. Statement or advertisement with respect to the sale or rental of a dwelling. Under the Act, we cover just not rentals, we cover sales and financing of real estate and properties. That indicates any preference, limitation, or discrimination based on protected class. When I talk about protected class, who here knows what I'm talking about when I say protected class? Okay, good. And that's important. Because again, they played their music loud. Maybe it was the type of music. Strange smells are coming from that apartment when they cook. Okay, could be someone from the Caribbean. Could be someone from South Asia. Could be anyone, and it could really be not the smell, but the people who are there residing in that apartment who are cooking. That could be the bottom line and the reason why they're being subjected to adverse treatment and actions. Okay. And again, that indicates a preference, limitation, or discrimination based on protected class. Interference, okay, which is important. It shall be unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of, or on account of his or her having exercised or enjoyed, or on account of his having or her having aided or encouraged any other person in the exercise or enjoyment of any right granted or protected by Section 3603, 3604, 3605, and 3606 of this title. It's Title 8 under the Federal Fair Housing Act. The corollary for that would be, I think is the next slide, would be for us, retaliation under the Act. They participated in an activity that's covered under the Act. Absolutely covered. And sometimes, like I say, it's not the crimes to cover up. Okay? It might not be the underlying complaint or the underlying protected activity that they engaged in, but the reaction to it. People have an absolute right to assert their rights. People have an absolute fundamental right to file a complaint with the Pennsylvania Human Relations Commission, with HUD, with EEOC, with any agency that's tasked with enforcing people's rights. And in this case, respondent's conduct constituted coercion, intimidation, a threat, or interference. Respondent's conduct is because of protected class. That's the link. That's the nexus between the action and the reason why the action was taken. Complainant's exercise or enjoyment of a fair housing right is affected. Key, the adverse action, the harm, that is what's affected. What is severe and pervasive? Now, one of my favorite, I used Schwemm, and I believe it's Robert Schwemm. I love Schwemm. Schwemm has several publications. The one that I dearly love, and the one that keeps disappearing off my desk because the attorneys in my office love Robert Schwemm too, and I've had classes, trainings with Schwemm, is a book about that thick. And the one I'm talking about is Housing Litigation, and it basically deals with the litigation practices and terms. It's wonderful. You can order the additions, change them out, add them up when they change and update the law. Schwemm is the book. If you don't have Schwemm, get Schwemm. It's expensive, but it's worth it. It gives you all the law and litigation, all the current law and litigation in fair housing. Under Schwemm, interference under subsection 3617 should be interpreted to include any neighbor harassment that would reduce a reasonable person's enjoyment of his home, her home, sufficiently to raise the prospect of having to move. The harassment, the adverse action was so severe, the person said, I can't stand this anymore, I have to get out of here. Generally, that's going to happen more in a rental situation as opposed to homeowners, but there are times when homeowners are discouraged from continuing their habitation of the unit because of the continual and ongoing harassment, sometimes not just the neighbor, but other actors within the neighborhood also who aid and abet the discriminatory actions. Other options: coercive, threat, and intimidate. Doesn't explain what fair housing rights need to be previously implicated. The best theory to use when we investigate these types of cases would be use and enjoyment. Okay. Now, if I can kind of read down a little lower, acts of harassment count both when done during the search for housing and after the individual moves in. Okay? You could show up to a property and all of a sudden your realtor or the realtor showing you the property starts getting menacing glares from neighbors, starts getting comments from neighbors, starts being intimidated and talked to. You don't want that person to buy that house. Oh, we don't want them in this neighborhood. It happens. Even having public meetings where, and I've had one case like that where the opposition to a party moving into a commercial property was so great that the people who were aware who the realtor was at public meetings would not only give out the realtor's office phone number and office address, but to give out the phone number and his address to his home, would give out the phone number and address of his wife's place of business, okay? And they would show up. And what ultimately happened was, this was a treatment center. And what ultimately happened was the realtor withdrew from dealing with this individual. So there's all different kinds of forms that this coercion and intimidation can take place. And that's a bad one. Your family's involved, they didn't sign on for that. And neither did that realtor. You tend to back off of it, and then that person, again, is harmed because of that action, that coercion and intimidation. The HUD rule, Title 8, okay, confirms that conduct involving the following is illegal or unlawful: threatening, intimidating, or interfering with persons in their enjoyment of a dwelling because of race, color, religion, sex, disability, familial status, or national origin of such persons, or of visitors or associates of such persons. And we have under 24 CFR subsection 100.400. Just as a point, it's kind of as a point of reference here, who could tell me in here what does 24 CFR mean? Anybody know what 24? I know we have attorneys in here. Does anybody know what 24 CFR means? Going once, going twice. CFR, and you see that a lot when you read the codes, is Code of Federal Regulations. And there are 50 titles in terms of codes of federal regulations comprising the U.S. Code for federal agencies. Under HUD and Fair Housing, it's Title 8 is the code, 24 CFR. Now, under subsection 3631, which is the criminal corollary, whoever, whether or not acting under the color of law, a lot of things happen under the color of law. A lot of bad things happen under color of law. George Zimmerman, that kind of ring a bell? Okay. A lot of other things happen under the color of law. By force or threat of force willingly injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person because of his race, color, religion, sex, disability, as such term is defined under section 3602 of this title. Familial status, again, the presence of children under 18 years of age, or national origin, and because he or she is or has been selling, purchasing, renting, financing, occupying, or contracting or negotiating for the sale, purchase, rental, financing, or occupation of any dwelling, or applying for or participating in any service, organization, or facility related to the business of selling or renting dwellings. This is just not your mom and pop, okay? I got this unit, I'm gonna make some money. I'm gonna make some extra money. You're talking about major management companies that know better or should know better. You know, I worked for a major building developer when I first started my housing career. Oh God, 40, 50, I don't know how many, 100 years ago. And I can guarantee you, they knew what the law was. They knew and were scrupulously aware that it was enforced because they knew what the penalties would be. They had a great relationship with HUD, and before with any of their projects, they had really great active monitors that were out of the properties, reviewed files, looked at demographics of the population, the tenants they had, and provided training and offered training. They know. There are times when, because again of the demographics of the area, they choose to do something different. They choose to look the other way. They said, oh, we don't want to scare any tenants away from here. We want a certain type of good tenant. You know, we have a good homogeneous community. I hear that and I just go nuts. You know, I lose even more hair than I already have over the years. So that's always a real problem. You have to watch for that. You know, the language is important. Words are important. What people convey and say are important. It either gives you a feeling of community and belonging or a feeling of, oh, I don't want to even be here. You know, like get out. I don't want to be here at all. Now, can everybody see this? Okay. What's wrong? That car is kind of jacked up. You know, what's wrong with the car? Somebody tell me what's wrong with this car? Let me move back a little bit so you can see. This is the result of neighbor-to-neighbor harassment in the extreme, okay? Clearly, the neighbors or a neighbor in the neighborhood maybe next door, maybe down the street, does not want this family to be there, okay, at all, because of their own biases and prejudice. And basically, this is due to religion. You know, it could have been national origin, could have been ancestry. You know, the ancestry wasn't up there, but ancestry is one thing that's covered under the act. It could be that. And it's go home Muslim, okay? The windows are broken out, the car is graffitied, the tires are flattened, and this is in the garage, okay? This wasn't even in the street. This is in the garage. So these people invaded this complainant's home, damaged this property. Now, if you come home and see all of this, you might decide you don't want to live in that neighborhood anymore. You may leave because you're worried about your safety. You're worried about the safety of your children and your family. You're worried about your investment. You know, most people's biggest investment are their homes. You know, what's going to happen next? You're going to throw a brick through the window? You know, is there a firebomb going to come through the window? Is someone going to drive by and shoot up my property? This is the extreme. I would say this is a harm. Big time. I would say this is a harm. And this happened in 2017 in Cincinnati, Ohio. 2018 in Toledo, Ohio. Ohio's on a roll. And it states a woman was arrested for spray painting a racial slur and swastika on her neighbor's house. And it also spray painted Hail Trump. You can see the N-word, and it's not Nubian, that was sprayed out on here, was sprayed out, keep out. And this is from a newscast broadcast. This is July 14th, which is Bastille Day, which is interesting. Toledo police says a woman spray painted Hail Trump in a racial slur on a neighbor's home early Saturday, about 2 miles just before Toledo's annual African American Day Parade. And again, if you came home to this, if your children came home to this, you'd have to seriously consider whether you wanted to continue living in that neighborhood. Yes, ma'am.
Would that, for our purposes, would that be criminal act versus?
We're going to get there. No, you're right. You're on the right path. That's great. You're on the right path. We're going to get there. But this would coerce. This would intimidate. Darn sure would harass the people there. Okay? And again, you may choose to move, or you may say, no, I'm not going to be, driven out of my neighborhood. I'm going to stay here and stick it out. I'm going to fight this. Okay? But that's a heck of a decision that you have to make. Like I said, your principles or the protection of your family. That's a tough decision. That's a real hard one. This person was arrested and was prosecuted, fortunately. But this happens a lot more than you think. this happens a lot more than actually is reported. There's a commercial on that I've seen, and I really like this commercial, where a woman and her daughter were going to their car, and the neighbor next door, who they didn't seem to have a real close relationship with, was working on his car, and the woman happened to be Jewish. And when she came out, there was swastikas and slurs on her garage door. And she kind of shooed her daughter into the car, and they drive away, and the guy's kind of looking, and she's looking at him like, you may have done this. She comes back home, and it's gone. And she's still looking at this guy, and she looks down and sees paint on his shoes. He covered it over, and she nodded thank you. So not everybody in a neighborhood where these actions take place are in agreement with this. But again, it's tough. You have the courage of your conviction. Are you going to stand up for other people that you may not be real close to for what's right? You know, people have a right to live wherever they want. You know, there are still neighborhoods that are very segregated. There are still neighborhoods that are not diverse. You know, personally, I would not want to live in a neighborhood that's not diverse. I would not want my children to grow up in a neighborhood that's not diverse, where they see different people, hear different languages, see different customs. You know, I'm fortunate to live, all of my communities that I live in is primarily African American, and my street is fairly diverse. You know, I've had, neighbors, it's a cul-de-sac and all homeowners, and I've had neighbors that have neighbors from Saudi Arabia. I have neighbors from Mexico. You know, I have neighbors from right across the tracks in a more affluent area. So to me, that's a stronger neighborhood. That benefits me as a person. I get to learn about other people. I get to learn about other cultures. I get to appreciate other people and other cultures. And it just strengthens our bond as a country and as a group of people to have those kinds of diverse neighbors. But let's face it, some people, hey, they don't want that. They'll move as far away as possible, or as we say, West Hell, to get away from, you know, people that aren't just like them. And that's a real major issue. But again, this person was dealt with. Okay, taking action. And this kind of starts to segue back to your question. There are criminal investigations that can be instituted through the FBI, through the local police, but usually with those, there's no actual monetary damages for those individuals. However, what I always would tell people is go talk to the DA. Okay, go talk to the DA, because generally in many jurisdictions, they have funds for victims that can help reimburse them for costs of medical treatment if there's a physical assault, can help reimburse them for costs of damages. So they should always circle back and talk to the DA, because there's usually in the local magistrate's office, there's always an ADA, Assistant District Attorney, there on certain days that you could file with. You can go right down to the DA's office and file. Okay, and there's other jurisdictions you can talk to in terms of criminal types of recourse. State police, okay, are really good. I found that we work with the state police, and they've been great, and local sheriffs. Many times you work with them. The FBI, it's interesting. We in our area, we had a cross burning not that long ago in a county outside of Pittsburgh, Indiana, PA. And the FBI was involved. Now, as part of their training, and they were training us on hate crimes and color of law, and one of the things they did was they actually brought the cross that was burned on the black family's lawn. They actually brought the cross. And they investigated the case. They found out who did, because this was even before Ring cameras, but some of the neighbors came forward, identified the people, and they were in the neighborhood, who actually burned the cross. And then they prosecuted them, and each one of them got 5 years in prison for burning the cross and ethnic intimidation and I think arson too, and a few other things that they put in there. But there was a punishment for it, and that activity ceased. The homeowner had no further problem. African American homeowners had no further problem at all after that, because the FBI was right on top of it and it prosecuted them. Now, under a civil investigation, which is somebody like us, there's city commissions, there's local human relations commissions, HUD and FAP agency, which we are, under fair housing laws, there are damages for victims. There's damages for individuals who have been discriminated against and subjected to neighbor-to-neighbor harassment. Certainly, you're looking at under housing, and one reason I love housing is housing has a lot of teeth under the statutes for discrimination. You're looking at compensatory damages. You're out of pocket. If we go to hearing, we always ask for punitive damages. I've never gotten any in my cases, but we will always ask for punitive damages, like a punishment for the behavior. Damages for emotional distress. Very important, okay? Very important. And damages, the biggest area where the damages come to play is damages for embarrassment and humiliation. Large awards, very large awards for damage, for embarrassment and humiliation, and there's a civil penalty. $10,000 for the first count, and after that, $25,000, and then it goes up incrementally. So it can be very, very costly to discriminate in the Commonwealth of Pennsylvania in terms of housing cases. Housing-related harassment, and we discussed it kind of briefly. Cross burnings, racial, religious, and ethnic verbal slurs, written graffiti, threats to interfere with living situation, hate-filled flyer distribution, and that's kind of a big one. You see that a lot. Now, you wake up in the morning, you look at your lawn, and you have all kinds of pamphlets and brochures all over the lawn or tacked upon a telephone pole or in the neighborhood. I know in Pittsburgh that's happened, particularly surrounding Tree of Life that took place 5 years ago in Pittsburgh. Periodically, you have white supremacists or neo-Nazis will come out, and particularly in the Squirrel Hill neighborhood, which is one of the largest Jewish neighborhoods in the United States. It's like the second or third largest. And they would find these tacked up on telephone poles. What happened was the Pittsburgh police, someone's ring phone recorded the person while they were distributing it, and they identified them, and they arrested them, and they prosecuted them, for the harassment. So those are some of the just manifestations of it. Attempted arson. There are times when, like I said, you get a firebomb sailing through your window, in your garage. You get things, people who've had Black Lives Matter signs that were burned, set on fire. I think that's one of the Proud Boys. Terrio is being prosecuted for that alongside of the sedition charges. The church had a black flag, Black Lives Matter banner. He set it on fire. He's being prosecuted for that, and that's arson. That's actually arson. Criminal assault, battery, or murder. And there have been crimes where people have been assaulted, where people, especially in a situation where you're right next door to somebody, either in a rental situation or if you own the property. It's more than just the property line. It's more than your tree branch is growing over the fence over into my yard, or your little yappy dog is running into my yard. It's more than that, and sometimes they end up in physical assaults. And sometimes, unfortunately, in some places in this country where you have open carry and anybody can have a firearm, people tend to settle their disagreements with violence. Someone opens the wrong car and they get shot. Someone rings the wrong doorbell and they get shot. Okay? I mean, it's just totally ridiculous things that happen. So it's something that we deal with every day in our society. I mean, you see it every day. I mean, you get tired. I know I'm tired of there being another shooting. And you look at it, it's something that's so ridiculous. It has nothing to do with self-defense. It has everything to do with bias, okay, either implicit or overt. It happens all the time. But what if it's less severe than this? These are obviously the really severe manifestations of this kind of discrimination and harassment. But what if it's less than this? Bottom line, it is illegal for a neighbor to harass a neighbor based on a protected class. Another neighbor in a manner that would reduce a reasonable person's enjoyment of his home sufficiently to raise the prospect of having to move. Your home is your sanctuary. Okay, it's the one place you can go, generally, where you have peace. We can kind of shut the door and you shut the world out. You're okay. You're in a safe space. If you don't have that safe space, life is miserable. Life is miserable. You expect your job sometimes to be tough. You know, working for PHRC is heaven, so it's not tough at all. He said, sure, right. I was going to say that, but no, I really do believe that. But home, I don't expect that I'm going to have any problems. I'm fortunate. I have good neighbors. I live on a cul-de-sac. It's 18 units there of townhouses and single families, all homeowners, and I got great neighbors. Stick together. Someone has, as I said, death in the family. Everybody kind of bands together and provides comfort to our neighbors. I love being there. I can't see being any other place. Not everybody is fortunate like that. I lived in dormitories for 4 years. It's like having to share a bathroom with 20 other people. Ugh, that was awful. And in apartments where people are just boom, 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 in the middle of the night, washing clothes in the middle of the night, bumping walls, all kinds of stuff. So when you're in your own place and you can just shut out the world, that's wonderful. That's wonderful. It helps you, gives you that balance. When we talk about that work-life balance that we all try to seek. So it's a bad thing when you don't have quiet enjoyment and peaceful possession of your own property. What's the right statutory fit for neighbor-to-neighbor harassment? You have to ask, what is the relationship of the complainant to the harasser? Is it the neighbor? Is it a rental situation? Is it a situation where they're homeowners? Is the harassment coming from the management agent or the landlord? Okay, or the housing provider? Is harassment coming from some guest of a neighbor? Okay, or is it coming from somebody even outside of that neighborhood? Or someone coming to the property of a neighbor to do some work, commercial aspect. What protected class is the harassment based on? Okay, what protected class? Is there any issue with the severity of the harassment? Again, if it's somebody standing across the street kind of flipping somebody off, is it somebody across the street that's flying a Confederate flag in the window? Or is it somebody actually threatening your children, threatening you, throwing stuff into your yard, or coming across onto your property making threats of intimidation and coercion and harassment? Are there any, and this is the fun part now, are there any, we call them 1A, and 1A is First Amendment. Are there any First Amendment defenses to be concerned about? Now, under the Federal Fair Housing Act, again, Title VIII of the Civil Rights Act of 1968, which was passed in the wake of the assassination of Dr. Martin Luther King. And what that did was open up a lot of neighborhoods for people to be able to live. And again, you had flight, you had white flight from those neighborhoods. You had realtors that steered people to other places that were like the person trying to buy the homes. You had block busting. And that had been happening historically anyway. But really, once that act opened up, the neighborhoods really started to happen. Okay, a lot. And that's a problem. And that prohibits discrimination because of race, color, national origin, religion, gender, disability, and familial status, which was actually added to Title VIII. They amended Title VIII in 1988 to include that. I believe they amended the Pennsylvania Human Relations Act to include that in 1991, I believe. Now, another question. Who here can tell me what et sec means? See, I'm being a pain today. Who can tell me what et sec means? You see it all the time. Ooh, what did you say? And means, and what follows? Using the page references. See volume 35, page 229, et sec. So since you were able to do that, there you go. See, you get prizes in my presentations. See, in my presentation, you get prizes if you answer questions. You get prizes. Okay. Et sec. Under the Pennsylvania Human Relations Act, The Pennsylvania Human Relations Act prohibits discrimination in all housing transactions, including but not limited to sales, rental, finance, providing reasonable accommodations or modifications to housing or commercial properties based on protected class, race, color, national origin, religion, gender, mental status, disability, and age, ancestry, and pregnancy. Age is over 40 and above. How many complaints have you seen or we see where someone says, oh, they're younger than me and they got that job or they got that housing and I didn't? Now you look at the age of the complainant and they're 60. You look at the age at the person who supposedly got the advantage and they're 55. Okay? They're both in the protected class. Now if you had a housing provider that said, I'm only renting to younger people, they have more disposable income. You're retired, your income is fixed, and you're 65, and they're all under 40, yeah, I would love that case. That's easy. That's my job real easy at that point. So it doesn't work when the parties are the same. It can. Now let me say never. And I always say maybe. When someone asks about it, don't you think it was discrimination? Maybe. It depends on the facts, of the case. Maybe it is, maybe it's not. But age is included also as protected class. Under the HUD regulations, under 24 CFR, subsection 100.600, harassment is defined, this is important, is defined as a single incident of harassment because of race, color, religion, sex, familial status, national origin, disability, that may constitute a discriminatory housing practice where the incident is sufficiently severe to create a hostile environment or evidences a quid pro quo. Next question of the day. Who could tell me what quid pro quo means? Very important in a harassment case. Whoops, lose my glasses. See, you get stuff. There we go. Quid pro quo, very important. Whoops. See, that's why they don't trust me with nice stuff. Okay, and B, 24 CFR, subsection 100.400, interference. It shall be unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of, or on the account of that person having exercised or enjoyed, or on account of that person having aided or encouraged any other person in the exercise or enjoyment of any right granted or protected by this part. Before I go to the next slide, what would be the corollary to that under the Pennsylvania Human Relations Act? Nope. Oh, there we go. See, we're getting down to the good stuff. I can use my glasses. There we go. That's good for tension, too. Sit there, although we're teleworking. You can sit there and do that all day if you want to. Do this again. Let's do this. Okay. All right. Now next. Prima facie case for your proof guidance. When you do these investigations, you want to frame your investigation around these points. Was the fair housing protected right affected? Was the conduct that intimidated, coerced, or interfered with rights? Was there speech involved, and was it protected by the First Amendment? What is the evidence that connects the fair housing right to the conduct? Now, another one. Who can tell me what prima facie is? Very important. Who can tell me what prima facie is? It's getting better. There you go. You might like those better than bubbles. There you go. Okay, on its face, on its surface. Very, very important. Very important. Now, if you look at the definition of prima facie, on first impression, accepted as correct until proven otherwise. Okay? First blush and first impression. Very important. Okay. Assessing credibility. This is always one that drives me nuts sometimes because I always have to caution investigators. You know, you're not here necessarily to ascertain who's telling the truth, who's lying. In my experience, everybody embellishes, okay, to make their position seem that much stronger. You notice I said embellish. I'm being polite. Sometimes it's more than embellish, but it's really important. The harassment claim often comes down to the credibility of the complainant and the respondent due to the nature of the complaint. There are times when no one sees it, okay? There's no witnesses there. You know, it's a neighbor to neighbor, okay, type of thing. Your fence is on my property, which is the nexus of the dispute. Or your kid's ball keeps rolling in my yard, or you're blocking my driveway, or fill in the blank, okay, a lot of times. In your investigation toolkit, you should have, and it's not a complete investigation unless you do, you should have a complainant interview. Party making the complaint. Complete interview. Do you only want to talk to them one time? No. You want to talk to them multiple times. The story should hang together. And then just the way the human mind works, sometimes you remember something or you bring up something you didn't think was important that's important to that investigator in terms of the veracity of your claim. Multiple times, but you have to talk to the complainant, and I'm not talking about when you first call them and say, oh, did you get the complaint? You know, was it right? No. Multiple times, every opportunity you can get to help me to understand. I would say this to complainants. Help me to understand what you're saying. Help me to understand what you're alleging is your harm. Okay? Very important. Respond and interview. Okay? Now, housing, like employment, usually at some point in time, the respondent will lawyer up, okay? We have, under our procedures, usually in housing, there's a 5-day call after the case is served. I always tell investigators, when you make that call, again, just don't say, oh, did you get the complaint? Oh, no. You have a golden opportunity to interview them before they get legal counsel, okay? That's not unethical at all. What it means is you get probably as close to the maybe unvarnished truth of the circumstances before you get a legal answer. That attorney is going to provide a legal answer for his client. You know, and I'm not mad at them for doing that. That's their job. They've got to defend their client to the best of their ability. So you will not have another opportunity to talk to them without their counsel or without their counsel's permission once they file a notice of appearance. You've got to take that advantage. And again, you've got to talk to them as many times as you can. We are a neutral law enforcement agency. You know, we're not advocates. So we're not, when we get a complaint, we're not saying that, oh yeah, you did it, we know you're a discriminator. We don't know, because we don't have the facts. And the only thing that we're going to deal with ultimately are what the facts are. Are the facts sufficient to say that more likely than not an act in violation of the Human Relations Act took place? Or if the evidence is just insufficient to be able to verify that an act took place. We call it 51%. Generally, if the facts push it that 51% towards cause, that's what we'll go with, generally. So that's the thing. Talk to the respondent multiple times. Again, help me to understand what your defense is. Help me understand what you're saying you didn't do and how you didn't violate the act. Third-party corroboration, okay? Good way to be able to verify an allegation or a defense. A lot of times, third-party corroboration are people who don't have a dog in the fight, okay? They can say, yeah, yeah, they didn't get along. Yeah, I heard him use the N-word. Yeah, complaining just as a pain with everybody. No, there's no validity to that, one way or the other. And third-party verification or corroboration can take many different forms. Witnesses, real important. People who have firsthand, direct knowledge of the incident or the action discussed. Okay, really important. I've had cases where a person says, yeah, I got a witness. Yeah, they can say everything I said is true. Yeah, you got to talk to them. Fine, give me the contact information. I talk to them. I don't even know them. I don't even live there. I have no idea what they're talking about. Or you have the exact opposite. Yeah, what they're saying is absolutely correct. Yeah, I went with them to help them complain, and the management agent didn't do anything. Just said, go call the police, and didn't do anything about it, okay? Witnesses to give you testimony against their own interest are great. I had a case where it was a refusal to sell case, and the respondent was accused of not selling or refusing to sell their property to a very qualified, overqualified African-American female buyer. Oh, no, it wasn't that. The real estate agent was involved. Oh, no, it wasn't that. The son and son-in-law, son and daughter-in-law of the respondent at a fact-finding conference said, no, it's absolutely true. Use the N-word, and that's one of the few times I ever felt bad for a respondent, because that must have been an interesting Thanksgiving in that household, for sure. So that is important. Again, people who give you testimony, witnesses who testify in a situation where it's not going to be necessarily good for them, not favorable for them, who are testifying against their own interests, by and large. Written complaints. Oh, we never got any complaints. I'm not sure what she's talking about. You go and you request the files for the people who live in that complex, and you see complaint after complaint after complaint about a particular tenant that the housing provider takes no action against. Important. Or if the complaint says, yeah, I send them written complaints all the time, you go through the files and you don't see anything. Okay? So it's very important because, again, it's a way to independently corroborate a claim or defense. Police reports, medical reports, and sometimes these are not filed right away. Police reports are great. Ultimately, what happens in the neighbor complaint, the police are called. Someone calls the cops, and they come, and everybody's on their best behavior. They don't see anybody acting up. They don't see anybody being stupid, and they're standing there going, what? What do you want me to do? And all they do, they talk to the parties. They admonish them for misbehaving. They say, if I come back here and find that you're acting out, I'll arrest you. And then the complainant or the respondent sometimes will complain. They didn't do their job. They didn't arrest them. Well, they didn't see anything. There's no physical evidence that anything was done. All we have is a dispute between two parties. One case I had where they did actually arrest someone was that the respondent saw the complainant at a mall and punched him over the harassment, and the police arrested him for assault. But by and large, those reports are important because they're going to have a first-hand data and documentation as to what happened when they arrived. And again, that's evidence. That's something that you definitely always want to ask for. And interview the police. I found that the police are generally cooperative. Chiefs of police, I found they're cooperative. Magistrates, are cooperative. They generally will talk to you about any information they have. They may say, I don't know anything. They may say, yeah, we're there all the time for this. for this nonsense. So those are really important pieces of evidence and prior statements of the respondent. And when I say that, social media is the death knell of a lot of people, a lot of employees, a lot of respondents, and a lot of complainants too. People, for whatever reason, want to put all their business and all the pictures on social media. My folks are really good, particularly my intake folks are really good at going into social media, Facebook, and pulling up stuff on people and being able to put that in the case file for the investigator to be able to follow up on. So that's really, really important to be able to look at. Now, the defense or pretext evaluation. I consider pretext is the true nature of affairs. Pretext is let's just say the omissions sometimes, the real bottom line as to why an action was taken. I didn't do it. I don't know what you're talking about. I didn't do it. Police reports and witnesses. Good corroboration. It wasn't intended to be discriminatory. You can't take a joke, okay? Sometimes, it's not meant as a joke. It's meant for a reason. It's meant as a verbal assault. It's meant, again, for the harassment element and the coercion. Look at the content and the context, okay, of the defense. In a discriminatory statements claim, it's not going to matter, okay? Basically, they said what they said. They said what they said. And again, is it pervasive and is it severe in terms of harassment? It wasn't intimidating or coercive. I came across the street with all my boys with baseball bats. Yeah, it's kind of intimidating and coercive. And that's maybe a little bit of an exaggeration, but sometimes it's not. You have whole families that get into some of this stuff, and it's meant to be intimidating. It's meant to set a tone. It's meant to enforce a certain type of behavior that person wants, for sure. Use a reasonable person standard in the place of the complainant. That's kind of tricky because sometimes you think a person's reasonable if they're really not. What bothers one person doesn't necessarily bother another, but it's a fairly fair standard. Does this shock the sensibilities? Is this something that, again, in a normal, civilized type of relationship, if that would offend you, if that would bother you, if you would say, that's stupid, that's insane, they shouldn't have done that. This is a squabble between neighbors, okay? I hear that all the time, or I used to hear that all the time when I investigate cases. And again, it could be a squabble. It could be a squabble, but it could also be a squabble that's based on protected class. It could also be more than a squabble. It could be harassment of that person because of their protected class. Yes, ma'am.
If you find out that it is a squabble and it's back and forth, and one party engaged in, both parties back and forth are engaged in discriminatory harassment behavior, who gets the PC?
Yeah.
Just the person who filed the complaint, even though we had evidence that the complainant engaged in maybe retaliated?
That's a good question. It could be retaliation. It could be that they filed and there was just no corroboration. It wasn't pushing that 51%. You really couldn't make a determination as to who was the perpetrator of the thing. But the person, say the respondent, went ahead and threw a brick through their window or did something else that was an adverse act. Then you could file the PC or write the finding for retaliation. That's where, when they talk about corroboration of facts, it's real important. Interviews are real important. And sometimes you just don't come up, boom, it's a blank. There are times when these cases are ripe for mediation, okay? Trying to settle these cases. The Act requires us to attempt to settle cases at any point in time in the process. And sometimes it's a matter of a third party coming in who knows the interests of both parties to try to get them to meet halfway to settle their complaints. And sometimes I've seen where you could say something as simple as, well, if the fence is on your property or his tree branch is growing over, go talk to the code enforcement people. They can enforce that. They'll get to try to get the police to do the job of the code enforcement people, and the police a lot of times will say, hey, that's not what I do. I've had complainants do that, end up filing a complaint against the code enforcement people because when they went to the property, they saw all kinds of violations that the person had and found out that it wasn't the story that the person was saying wasn't quite the truth. So it's going to be what facts you have to work with. And if the facts are not sufficient to say that more likely than not an act of discrimination took place, then that's what you've got to write in your finding. You know, they won't like it, but that's the responsible thing to do. Okay, he started it. He started it. How many times? I used to say that all the time with my sister or my cousins. They started it when I was getting ready to get in trouble with my parents. He started it. Okay, sometimes it doesn't matter who starts it. Sometimes it doesn't matter because it's where it starts is not always how it ends. Okay, it can start over something that is otherwise not discriminatory and end up into a situation or behavior that is discriminatory and a violation of the act. So when I hear he started, I go, okay, fine. What did he start? When did it start? What did you do? I mean, you have a whole line of questions you have to answer to try to ascertain, the facts about the case. And who brought in protected class? Oh, they're just playing the race card. Oh, no. It may have been that party brought in the protected class when they made the comment that they made, when they used a racial slur, when they said something that otherwise, a statement that was otherwise a violation. It's the behavior, the violation of the act. First Amendment as a defense. It would be a mistake to overlook the First Amendment in discussing neighbor-to-neighbor harassment. That being said, speech intended to coerce, intimidate, threaten is not protected. And I'm going to say that one more time because it's important. Speech intended to coerce, intimidate, and threaten is not protected. You're looking at the behavior, not so much the words, but the behavior that is the violation. Speech directed at unwilling audiences and at people in their home where they are entitled to peace, quiet enjoyment, is less likely to be protected. Harassing speech is less likely to have a legitimate or important constitutional concerns. First Amendment is always going to be a defense in neighbor-to-neighbor harassment. This is important. This is the source of the law. And this is a case that is a really good case, good seminal case on that. Wetzel versus Glen St. Andrew Living Community, LLC. Now, the rule, it not only does the Fair Housing Act, again, 42 USCS, I won't ask you what that means, USCS subsection 3601, 3619, 23619, creates liability when a landlord intentionally discriminates against a tenant based on a protected characteristic. It also creates liability against a landlord that has actual notice of tenant-on-tenant harassment based on a protected class, yet chooses not to take any action, any reasonable steps within its control to stop the harassment. How many times have I heard landlords say, oh, I don't get involved. I just tell them to call the police. No, that's their property. They've got recourse in terms of the behavior of the individuals who reside in that property, even with a magistrate, okay, that we have no jurisdiction over, but as another type of court or authority, they have, the ability to adjudicate these cases where there is a harm and a motive other than, oh, it was just a squabble, and there's harm to a party to stop the harassment. The HUD rule, which was issued in 2016, very important, is under section. Sure. Pardon me? Oh, sure. Let me get out of your way here. You're quite welcome. Okay, section 100.7A1 of this final rule provides that a person is directly liable for failing to take prompt action to correct and end a discriminatory housing practice by a third party, where the person knew or should have known of the discriminatory conduct and had the power to correct it. So, yes, ma'am.
I'm sorry, what course does the landlord take to correct that action?
We're getting ready to get to that. Okay. We're getting ready to get to that. I think it's the next slide. Now, this is actually, we'll get to that. This is actually this case that we're talking about that prompted the revision of HUD's act. Within months of her arrival at Glen St. Andrew Living Community, St. Andrew, Marcia Wetzel faced a torrent of physical and verbal abuse from other residents because she is openly lesbian. Time and again, she implored St. Andrew staff to help her. The staff's response was to limit her use of facilities and build a case for her eviction. She's the one complaining, so let's get rid of her. No one else is complaining but her. Wetzel sued St. Andrew, alleging that it failed to provide her with non-discriminatory housing and that it retaliated against her because of her complaints. Each in violation of the Fair Housing Act, the FHA Act, 42 U.S.C. 3601 to 3619. St. Andrew insists that the act affords Wetzel no recourse because it imposes liability only on those who act with discriminatory animus, an allegation Wetzel had not expressly made of any defendant. The district court agreed and dismissed Wetzel's case. Okay, now, this is important. Everybody has due process rights. Everybody has recourse, so that when, say, a case is found to be no cause, even in our procedure, people have an ability to appeal the finding. In a court, you have the ability to appeal to the higher authority. The court held, and this is the Seventh Circuit Court, the court held that Wetzel's suit was erroneously dismissed for failure to state a claim because under the FHA and PHRA, the duty not to discriminate in housing conditions encompassed the duty not to permit known harassment on protected grounds. The harassment was severe and pervasive. The definition of harassment, severe and pervasive. And the landlord was responsible for the building's common areas where most of the harassment occurred. And the incidents within Wetzel's apartment occurred because the landlord was exercising a right to enter. And I think under, that's the limited warranty of habitability, no entry by landlord. I think under the Pennsylvania Act, that's where that section is. Landlord doesn't have a right just to walk in your apartment. They have to give you notice unless there's an emergency. And I've had any number of cases where sexual harassment was alleged because someone's in the shower and landlord walks in, hey, what's up? How you doing? And they're in the shower. So that may be their property. And I always state this to people. That may be their property, but that tenant is in legal possession of that property. And the only party that can return that possession back to the owner is the magistrate or court, a court. The magistrate being what's called the minor judiciary. They can do that. But no, you don't have a right just to waltz in there. They don't have that right. Now, holding a housing provider accountable. This is your question. 4 requirements. The housing provider had the power, in this case in Wetzel, had the power to correct and end the harassment. The housing provider knew or should have known of the discriminatory conduct. The housing provider fails to take action that it knew or should have known they would be successful in ending the harassment, and the conduct of the harasser rises to the level of severe and pervasive. And illustrative examples, corrective actions that housing providers should have taken to cure tenant-on-tenant harassment, verbal and written warnings, enforcing lease provisions to move or evict or otherwise punish. Landlord has a lot of power in terms of you residing in their property. You got a lease. It's a contract. The lease, I've written leases. I've written a lease or reviewed a lease that didn't give as many advantages to the landlord as possible. Okay? So, and they signed the document. They signed the contract. So they're going to be held accountable to that contract. So if the contract says you will not disturb the quiet enjoyment of your neighbors, you will not harass them in any way, and you do, and I know you're doing it, I can say you got a choice. You can either stop the behavior or I'm going to issue you a notice to quit and start the process of eviction with the magistrate. They've got the ultimate power to decide whether or not, I need that too, whether or not you're going to continue residing at that property. Issuing no trespass orders or reporting the conduct to the police, because what they're doing may even be criminal. And that person has recourse of the criminal system. And I advise people, well, I don't advise people, I suggest to people, because we're not in an advisory capacity, that they have the right to file with police criminally and with us civilly in terms of filing a complaint. And I would suggest to them that they do both, afford themselves of both remedies, to be able to correct the action. Establishing anti-harassment policy and complaint procedures. And make sure that everybody understands that, knows that. Make sure that if you have an incident, you send out a notice to all your tenants saying, we will not tolerate this behavior. You don't have to call people out by name, but cite the lease and say, we will not tolerate this behavior, and any further occurrences of this behavior will be dealt with severely. You will be evicted. Okay? They've got the ultimate upper hand in these situations for sure, and there's no reason why they will say that, oh, we don't deal with that. Oh, talk to the police. Oh, go talk. No, you deal with it. It's your property. You have an obligation to your tenants, okay, to protect them and afford them the same rights and enjoyment in housing as any person there, regardless of protected class. Now, that is the end. I'm just saying, maybe mercifully, that's the end of my presentation. This is my address. That we can be contacted directly there. There's a perfectly wonderful regional office here in Philadelphia. Robert Lindsay is the regional director. They do great work. They have great investigators. They can be contacted. You'll have their contact information. Harrisburg, another fabulous regional director, great investigators, do good work. They tend to the people's work. I used to have a regional director when I was an investigator. He'd always call me by my last name, and he would say, Wood, are you attending to the people's business today? And I'd say, yes, sir. And he'd say, good, and then walk away, cryptic as ever. But we're attending to the people's business, okay? We are the recourse. We are the guarantors of their rights. We're not saying that in every case we're going to find that there was cause. Sometimes there is, sometimes there's not. We are neutral law enforcement. We will act and work with the facts that we find in the complaint and then move accordingly. If we find sufficient facts that, again, more likely than not, an act of discrimination took place and we're able to move it forward, we'll prosecute those cases. We've got wonderful attorneys. One just walked in. We have one right here. Great attorneys that are very aggressive, that will prosecute those cases. And in my time as an investigator, I've had 19 of my cases over 34 years that went to hearing, either in common pleas court, Commonwealth court, panel of commissioners, or hearing examiner. One thing about housing cases is for the HUD case, the respondent has a right to elect to go to Commonwealth court and have the case heard before a senior judge in Commonwealth court. That's fine. And my experience has been they know the law, they know the cases, and it always worked out for me, so I was happy with that when they would do that. So, people have to know what their rights are. It's our obligation to inform them and tell them what their rights are so that they, again, can enjoy that absolute right of housing and fair housing within the Commonwealth of Pennsylvania. And I want to thank you for being very patient. I want to thank you for not throwing stuff at me when I sang Mr. Rogers' song, which I promise I'll never do again. And I want everybody to have a great day, have a great conference, and thank you very much.
Thank you, Director Wood. Does anyone have any questions for Director Wood? Can you advance to the next slide? In the back?
Me?
Yes.
You don't need the mic? Oh, excuse me.
On behalf of the victim?
Again, as you saw, the property landlord or housing provider has an obligation to see the action enforced. So if they see that these people are violating the act by their harassment and intimidation and coercion of one of the other tenants there, who contractually has the right to provide employment, sure they can file. They can file. Yes,
What are the different landlords and tenants? I have one landlord, I'm complaining to my landlord about it, and the neighbor is a different landlord's tenant.
That's the problem. Because again, it's like I own and sexually harasses my employee, okay? Or in a case of a housing context, I'm a management agent and I have somebody on the outside come in and sexually harass one of my employees. You can file. I mean, you could definitely file. You have an obligation. You have knowledge that the action that they are engaged in potentially is a violation of the act. So you have an obligation. I don't want to say it's like an obligation to report, but it's an obligation to take an action. Okay, there's any number of things you could do. There's things you could do criminally. There's things you can do civilly to be able to stop, and that's the important thing, to attempt to stop the action and to correct the situation.
Would the landlord then have the right to say, well, that's not my tenant, you as a tenant need to then go file against them and their other housing provider?
That's going to be an interesting case because, again, what knowledge do I have, okay, that there actually was a violation of the act that took place? We're looking at knowledge. Do I have any first-hand knowledge? Am I aware that this is taking place? Am I aware this is a violation? Okay, or am I just going on hearsay that there has been an actual act? I still say you have an obligation, an interest. If nothing else, people deal with their self-interest. You have an interest to see that behavior is stopped. So they still can't bury their heads in the sand and say, ooh, I'm not going to deal with that. It'll just go away. Okay. Because it doesn't.
Thank you so much, Director Wood. Yes, yes. Yo, you're right on time, Director Wood. This is a first. I just want to thank you all for your engagement. It's important that as housing advocates and those who are tasked with investigating complaints, that we understand these particular nuanced type cases. As a housing investigator, when I was a housing investigator, I also had lots of neighbor-to-neighbor harassment. And like Director Wood said, sometimes it was just back and forth. But these are violent acts. These are just horrible acts. These are acts towards people's children. And I know, unfortunately, there was just an incident in Florida where the woman was shot through her door after the parent confronted her about harassing her children and killed her. And so it's our job to get to these complaints before something like that happens. Not to say that I don't know what happened down there, but it's just what we do is important. So I just want to thank you all for your engagement in that. Please take our survey, scan the QR code that is there. Please give us some feedback on this session. Please give us feedback throughout. Your feedback help us remain relevant and to continue having these types of dynamic discussions that engage us as advocates and activists. So we will be returning in this room for 11 o'clock for our session on gentrification. So you can feel free to go to the restrooms, take your time, and just be back here for around 11 o'clock. And please hold on for our Director Garcia. Oh, okay. Yes. Director Wood, would you mind coming up here, please? No, it's not. It's definitely not money. So many don't know that if you remember in the bio, I said that Director Wood has been working for PHRC for many years. This is Director Wood's last year here, correct?
I'm short, 2 weeks.
2 weeks before retirement. So we want to thank Director Wood for being here. Thank you for his career here at the Pennsylvania Human Relations Commission. And on behalf of PHRC and all those in attendance, I wanted to present you with this plaque. Just celebrating you, celebrating your contributions, celebrating the wonderful presentation and training that you've done, and just admiring the intellectual property that you bring to the PHRC. You're definitely going to be missed, but I'm sure we'll be working with you in other capacities. So thank you so much. Any final words? Don't cry now.
I'm trying not to.
Don't cry now.
I tried not to. It's been a privilege and an honor to have served with such great colleagues. I love every one of them. Their family. They've put up with me for 34 years. I have a lot of teachers that have mentored me. And I just want to thank everybody. Director Garcia, love work. You got here too late, man. You know, we could raise a lot of hell together. I mean, we could have fun, and probably still will.
Right,
Good
good
trouble,
trouble,
good trouble,
good trouble.
always. But I want to thank everybody. Like I said, I want to thank everybody for being patient and kind, and again, showing me grace as I tried to sing. So I want to thank you again.
Thank you so much. Thanks, Charles. Gonna miss you. So like I said, we can all take a break if you have to take a bathroom break, and we'll just be back here around maybe 5 minutes after. Okay, their session is still going on outside, so just be mindful of that as you walk through. Thank you so much.